Good morning, everybody. Welcome. Thank you so much for attending our first ever virtual event. My name is Kelly Perk. I'm an assistant prosecuting attorney in Cuyahoga County, Ohio, and I represent our Adult Protective Services and Board of Developmental Disabilities seeking protection for our most vulnerable in court. Also, I'm the current chair and the conference chair of the C3A, also known as the Consortium Against Adult Abuse. I don't know about you, but while I appreciate that technology gives us the ability to put our conference on this way, I really miss getting together in person. And I look forward to seeing you all in person next summer. I want to thank our conference committee, Natasha Petricola, Aaron Uranius, Samantha Brooks, and Janelle Leonard for their help in planning this conference, and to Bonnie Paduk, our administrative support from Western Reserve Area Agency on Aging, and Danielle Clay from the Western Reserve Area Agency on Aging, who assisted us in applying for our CEUs and putting together the evaluations and certificates you'll all be getting later. We want to also thank our sponsors who provided financial support for this conference and encourage you to visit their websites, which are linked to their logos here on this platform. Journey Center for Safety and Healing, Lutheran Metropolitan Ministry, Schraff Thomas Law Firm, Reminger Law Firms Foundation, Benjamin Rose, the Cuyahoga County Division of Senior and Adult Services, and OCAPS, the Ohio Coalition for Adult Protective Services. So just a couple of items before we get started. This morning's session is live and interactive. It will include a keynote speaker and then a multidisciplinary panel. It has been approved for 2.5 hours of continuing legal education and approved for credit for accountants as well. And the CEUs for social workers and counselors are pending. And once approved, your attendance here will be covered and we'll email you those activity numbers. Also included with your registration are 6 one-hour workshops, which have been pre-recorded, so you don't have to watch them today. You have until August 31st, 2021 to watch them. After each workshop will be a quiz, which is required by the various boards approving the credits to make sure you actually watch the presentations. You'll receive certificates and asked to complete an evaluation for those as well. We're going to also be applying for credits to make this morning's session available on demand for people who signed up or want to sign up later but can't make it this morning. So every year, except for last year due to COVID, we do this conference around the time of World Elder Abuse Awareness Day, which is observed on June 15th. The ribbon color for elder abuse is purple, the color of bruises. However, we know that abuse is not just physical. It is mental. It includes neglect and abandonment, and it includes financial abuse. So some instructions for using the platform. If you're listening to me right now, you've overcome the first hurdle, which is signing on. And it's very easy, I've found so far, to use this technology. I just click and I'm in. So your profile, if you haven't already, we recommend you click on your profile on the left-hand side of the homepage and edit the information. If you want to add a picture, social media links, or a bio, that could be a great way to help facilitate networking amongst the attendees. And then you can click on the attendees tab to see who else is participating in this event and connect with them directly here today or on their social channels like LinkedIn. We look for these live sessions to be as interactive as possible, so you will see a live discussion button on the bottom right of your screen. Please click on that and notice you can participate in chat, question and answer, and polling. We will be sharing your questions with our speakers as we go along, so please use these features to connect with your fellow attendees and our speakers. You can also use these features for the on-demand sessions to connect with other people watching the same sessions, even if it's not the exact same time as you. The on-demand session open up in the platform at 1 p.m. Eastern time, so after this morning's session and our meeting, and you can click on the sessions in that time and enjoy the content. You will see a link on each page for the quiz that is required for you to complete to get this certification. So please click on that after you watch the video and submit the quiz. We will then be in touch with information on your certification hours. Please note the live sessions from this morning will also be available on demand next week for you to watch again and take the quiz for credit. You'll get credit today for your live participation. That's a different process, but if people want to sign up later, you know somebody who might want to participate and watch the session from this morning, we'll make that available for credit. Okay, if you ask, okay, sorry, lost my place. Some people ask how they're, oh, okay, never mind. Okay, so if you want to test the chat feature, I'm going to ask you a question, and if you feel like it, you can, just test it out. So I'm going to ask everybody what they had for breakfast today. And if you want to just include that in the chat feature just to test it out. I had some cereal and I mixed in some grape nuts because I like the crunch. So that's what I had for breakfast today. I won't read your answers out loud, but if you just want to test it, that's great. So on that note, I want to introduce our keynote. Paige Ulrey is a senior deputy prosecuting attorney for the King County Prosecutor's Office. And King County is in Seattle, Washington. So she is up very, very early. It's not even 6 o'clock her time. So we thank her for her willingness to get up and share her expertise with us this morning. She graduated from Amherst College and Northeastern University School of Law. She began her career at the King County Prosecutor's Office in 1998. And in 2001, she was appointed to the newly created position of Elder Abuse Prosecutor in the Criminal Division. In that position, she prosecutes cases of elder and vulnerable adult neglect, financial exploitation, sexual assault, physical assault, and homicide. She conducts training and curriculum on elder abuse prosecution and investigation around the country and internationally, and she has testified before the U.S. Senate Special Committee on Aging and has twice spoken at the White House conferences on elder abuse. So with that, I am going to introduce Paige.
Thank you, Kelly, very much. It's such a pleasure to be here. I have spoken a number of times in Ohio, and it's truly my favorite place to speak. You guys are, I think, have an amazingly robust and coordinated system to respond to elder abuse, and it's just such a pleasure to see that because it's unusual. Okay, so I'm going to start this presentation and just a few preliminaries. First of all, thank you to Kelly Perk, Liz Caruso, also Jennifer Clark for their expert assistance in getting ready for this. Jennifer and Liz, your technology is fantastic. This is the best platform I've ever presented on, and I'm so grateful to be able to do that with you guys. And Kelly, your constant coaching and information throughout this process has been so wonderful. So I've got a pretty dense agenda this morning, and it's possible I may not get through all of the slides, but I want you to know that we are going to either send or make available to you this PowerPoint as a handout, so you can have it as a reference, even if I can't cover everything. What I will be doing is taking out the case example, so it'll be much shorter than what you're going to be seeing today, but it will be available to you. I also just wanted to say that even though I'll be talking about elder abuse, much of what I am talking about applies to younger people with cognitive disabilities, and I don't mean to be excluding them at all. It's just hard to it's not the same population, obviously, and I just don't want to be sort of gliding over that distinction, but I think you'll find this relevant to a lot of different populations. And finally, I need to hear from you. So I'm hoping you guys, it's so hard to talk to a screen and not be there with you. So we have a number of points where we want to hear from you and have a discussion, and so I'm hoping you guys will contribute to that. And there's one other caveat, which is that my dog is lying at my feet right now, and he likes to go in and out of my study. So I might have to pause for a second and let him out, or let him back in. Let him back in as we go along. Okay, so this is the agenda for today. So I've got a case example that I'm going to be actually weaving in throughout the presentation. But I'll start off by talking about Mariana, the victim in this case. And then I'll move into talking about giving you an overview of elder financial exploitation, and then talking quite a bit about dementia and capacity. And this is from my perspective, and I'm obviously not a geriatric psychologist or psychiatrist. I've just been dealing with this issue throughout the 20 years I've been handling elder abuse cases, and I have over time come to realize that it's absolutely essential to our properly responding to this problem. And so what I've learned from it, I've learned from geriatric psychiatrists and geriatricians that I've worked with, but I don't pretend to be an expert on that subject at all. So forgive me if I say anything that seems somewhat, I don't know, not completely like an expert would talk about. I'm also going to talk about charging elder financial exploitation, even though I know many of you are not in the criminal justice system. I think it's really, really important that we all understand what is and what isn't criminal when we're talking about financial exploitation. So this is probably more for those of you who work for APS or who work in social services than it is for the lawyers, because it's just incredibly important that we're all on the same page, and that you as APS investigators or people who are social workers know when you should be calling law enforcement and know when you should be talking to prosecutors if you feel like your case isn't getting the attention it deserves. And finally, I'll wrap up by talking about some lessons I've learned from this case and generally from working these financial exploitation cases. So we're going to start with the case example of Mariana. And just a little bit of background, Mariana, when this incident happened, was in her early 80s. She was long retired. Her husband had died a few years earlier. She lived outside of Seattle in her own home that she owned. She had a mortgage still outstanding, but it was her own home. She had 2 children, both of whom had children of their own, but she was estranged from her daughter at the time. And she, as you'll hear, she became closer to her daughter as this incident sort of progressed. And then she lived quite a bit of distance away from her son, so she didn't really see him. So she was kind of alone in life at the time this started. She did have a lot of friends from her church, but I think she was pretty solitary. So we have a video now we're going to play for you. It's about 7 minutes long, and it's an interview with Mariana and her granddaughter, Amy.
So that I had a neighbor that lived up the street. We were friends, and she broke her hip, and she went to the hospital, and when she was ready to be discharged to come home, a social worker inspected her home, and it was not safe. So she hired this lady, this Janet. She was an organizational specialist, and she came to clean her house so that she could return to her home.
My grandmother went up to help that person clear out the house so her friend could come home. The person who owned that organization company started showing up at my grandmother's house and befriended her. And so over a period of about a year and a half, this person became a regular person in my grandmother's life.
I was really surprised because we had very little in common, but she kept coming, and we became friends. And I was interested in her kids and her activities, and she asked a lot of questions about me, and in getting acquainted with people, especially friends, you tell them a lot of things about your life. So she had a good idea about my financial situation.
I think that with my mother dying, being terminally ill, this was a very difficult time in my grandmother's life. This was the most vulnerable she'd probably ever been in her life, to watch her child die of breast cancer that had spread to her brain. My mother had had a massive stroke that took out 1/5 of her whole brain. I think that as her daughter and as her mother, that this was a very difficult process for both of us. This person put herself in my grandmother's life and tried to fill that role of being a daughter. She was that person my grandmother could count on if she needed help doing something at the house. She was that person who asked how she was and how she was doing, and really showed an interest, which we now know was really grooming behavior, but showed an interest in my grandmother's life. Filled a void that had been taken away with my mother's illness and subsequent death.
She was just very helpful to me. And I guess I was maybe a little lonely because my other grandkids were, I didn't see them all the time. They're young, living their lives and working and that kind of thing. And I guess she just filled maybe an emotional gap. And I accepted it that way.
She would bring her children to my grandmother's house. She had her daughter come and bake cookies, or her daughter would come to show my grandmother how to do different things on the computer. She involved her children in creating this false relationship. And my grandmother, as I have said, was like a second mother to me. She helped to raise me. She would take in any kids who needed somewhere to go or needed love if they didn't get love in other places. So I think Janet knew that and used her children as a pawn to gain my grandmother's trust.
I began to feel that like she was part of my family. And that was the reason I kept giving her money. And she had the 2 kids. And I felt that but I was helping them. So that was the main reason I kept giving her money. But she would tell me she was in a car accident and she was waiting for a settlement, but she hadn't been released from the doctor, so she wouldn't get a settlement until he was through with her treatment. And she did that twice. She would call me, and she'd be in tears, saying that she didn't have the money for this or that, whatever it was at the time. And I fell for it, because I cared for her.
She requested money several times. I believe there were 15 to 20 different checks that were written as loans to Janet from my grandmother. Some of those checks were for a couple $100s, all the way up to checks for $50,000.
She said she would pay me back. She was always going to pay me back.
This person became the power of attorney, medical power of attorney, and executor of my grandmother's will.
I trusted her. I certainly wouldn't have done everything I did if I didn't trust her. Because I felt if it were a member of my family, I would have done the same thing. She kept promising. She had worked for a cosmetic company where she went to homes and took orders and then ordered the product that the people wanted. So she said that company was selling the company, and that they were having lots of meetings with the people that are going to be buying the company. And it was taking a long time for this to happen. And she had told me that it was going to be settled in October, I believe. And so I was sure I was going to have the cash. So I had a new roof put on. I needed it. And when I had talked to her and found out that that hadn't happened, I was stuck with that huge bill, and my credit cards were already maxed because of her. I didn't have any credit debt until her. But that left me just completely devastated. What was I going to do? Because I eventually had to finance it. But that's when I realized that I had really, really been taken. Why was I so stupid that I could not see what she was doing to me? And so November and December, I kept it to myself. And January, I couldn't hold it anymore. So I told my granddaughter and her husband. And they immediately started finding out what we had to do. And they both went through the process with me.
Okay, I'm hoping you guys can see the slides now. So I'm so sorry. It sounds like some of you might not have had the sound all the way through. So just in case, I just want to make sure everyone is aware of the facts here, or if you came in late or anything. So I'll just quickly go over them. Essentially, you just heard from Mariana Cooper. This is a real case, obviously. She described having met a woman named Janet Baumel who ran a home organization business, who was helping her neighbor. And Janet really was very proactive in befriending Mariana. And she very quickly told her about her life and talked about having 2 teenagers, having a lot of financial trouble. But she was very charming and very kind and empathetic. And as I said, Mariana was lonely. And so it felt to her like she had really found a friend. So she pursued this friendship. She started stopping by Mariana's house every day. And it wasn't long after that that Mariana's daughter, from whom she'd had this pretty distance relationship, was diagnosed with breast cancer. And Mariana started to get involved again with her daughter's life and began to help her granddaughter, Amy, who you saw in the video, provide care as her daughter declined. And within months, she died. The cancer had metastasized to brain cancer, and it was just an awful, difficult illness and death. And Mariana was quite heartbroken when it was all over. So at the time of her death, of the daughter's death, by this time, Baumel had cultivated this very close mother-daughter relationship with Mariana. This had been going on for a couple of years at this point. And she offered to help Mariana with her bills. And Mariana was struggling with her bills, but she just thought it was because it was something she'd never done before. I think her husband had always handled them in their relationship. And she became, Janet became her trusted confidant, and eventually Mariana signed a durable power of attorney, appointing Baumel as her attorney in fact to handle her finances, and also made her the executor of her estate so that when she died, Baumel would deal with her will. Then 3 years into the relationships, this is not an early incident. This is long after the friendship is well established. Janet begins to ask Mariana for money. And specifically, she says, it's going to be loans. I'll pay you back. I need this money to feed and clothe my children. She talked about a drug addiction that her son suffered from, that she needed to pay for. She talked about having been abused as a child and needing money for therapies and medical treatment, and then needing money to start this new business where she was selling cosmetics. So those were the reasons that she gave Mariana for needing money. And then she promised she would pay her back. Again, these were loans, and she was getting this big insurance settlement. She was going to be getting profits from this new company she was working for. And what we learned from having talked to Mariana in depth about this was that Janet became increasingly dramatic and emotional about this need for money. So as Mariana started to give her these loans, she sort of was drawn into this drama that Janet created. And it became increasingly compelling and clear to Mariana that she had to give her this money, or Janet and her children would not make it. So every time Janet asked her, Mariana agreed to lend her money. And Mariana herself, wrote these checks to Janet for the amounts that Janet requested and told nobody else about it. She felt like this was private. I'm sure she was worried about it and probably a little ashamed of it, but she didn't tell anyone, including Amy, about what she was doing. By the following year, Mariana had drained most of her accounts to help Janet. And then what Mariana described at the end of the video was she really needed a new roof on her house. And Janet was telling her, I'm about to get this money. So don't worry about it. And you'll be able to do whatever you need. So Mariana put the new roof on her house. And then when it came time to pay that bill, Janet had disappeared and was not anywhere Mariana could find. She would call her, Janet wouldn't answer. She went over to her house. She wasn't there. She did everything she could to try to locate Janet to get this money to pay her roof, for her new roof. So I'm just going to pause here and talk a little bit now about elder financial exploitation. And I know that everyone here is dealing with this in some way, and we're all aware of this, but I think it's important to go over some of the data And some of what I'll tell you about, I think, is also probably new information for some of you. So there was the Consumer Financial Protection Bureau did a study a few years ago and found that this was back in 2017, that there was $1.7 billion in suspicious transactions reported. Of those transactions, 80% of elderly victims lost an average of $34,000. A third of these victims was 80 years and older. The average loss was for adults aged 70 to 79, and the average loss was $45,000. And the loss was greater, and I think this is no surprise to any of us, with known suspects, averaging about $50,000 per victim. And still, despite sort of improving financial exploitation reporting laws across the country, we still saw only a third of these transactions being reported to authorities by the banking industry. So still a huge problem, obviously, with underreporting. And then I want to talk just briefly about a study that my office did with Cornell Medical School, and they do a lot of elder abuse research, as some of you probably know. And we just looked at all of the filed cases involving victims 60 and over in our jurisdiction, and in every form of abuse. And of those, 45% were financial exploitation crimes. So the vast majority of cases that we see are financial exploitation. It doesn't mean it's happening more than other forms. It probably is, but I think we also see huge issues around reporting with regard to neglect and sexual abuse. So I'm sure those numbers are much higher in reality. We also know that elder financial exploitation is most often committed by someone the elder trusts. We see it being committed by caregivers, by guardians, by financial advisors, by powers of attorney very frequently, by strangers who target and befriend the elder, and by family members and other trusted individuals. It's really anyone in a trust relationship with an older adult. And we know that it's hardly ever reported, and that's true for financial exploitation as well as the other forms, as I mentioned. But this study that was done in New York found that for every one case of elder financial exploitation that's reported, another 43 cases never come to light. And these are just some reasons why involved professionals don't report. I think for some people who are not trained, which is many of us, on these issues, it's really hard to figure out whether what they're seeing is exploitation or the elder's free choice. Obviously, it's different when we're talking about neglect or sexual abuse, but financial exploitation is particularly challenging because we have the right to do what we want with our money. We have the right to make what other people might think of as stupid decisions about how we spend our money. So to say to somebody, I'm sorry, I'm going to call APS or call the police on what you're doing is really difficult. And also, people worry about damaging their relationship with the elder, about intruding on their privacy, losing their business, liability. So all of these things, I think, contribute to the fact that we're not seeing involved professionals report nearly enough. We also don't see victims reporting very often. A study done by New York State recently found that 50% of victims of any form of elder abuse were largely unaware of their mistreatment, and only 2% of the reports that New York State got were actually made by victims. And this is just some reasons why victims don't report often. I think fear of losing independence is huge. The fact that many victims are in a very close relationship, often codependent relationship with the perpetrator, causes them to be afraid of retaliation. They may be emotionally dependent on the perpetrator. I think with Mariana, there's a lot of fear that if they report, they'll never get their money back. And I think that's particularly true of a lot of scam victims. You start getting invested in this exploitation, and then if you call the police, there's absolutely no hope that you'll get your money back, which is true, although there wasn't hope in the first place. And I think especially with different communities, we see a lot of mistrust of government and law enforcement. And then there's dementia, which prevents people from understanding their finances and recognizing what's happening to them in many cases. And this is just my own experience, but in the cases I've worked on over the years, these are the two most common risk factors that we see for elder financial exploitation: isolation and usually some degree of dementia, even if it's undiagnosed. So I'm going to go back to our example of Mariana. And what we know is that at the point when she needed to pay for this roof and she couldn't, and Janet had disappeared, she called Amy, her granddaughter. And Amy went to the bank with Mariana and got her bank records and learned that over a 3-year period, Mariana had written and signed 25 checks to Janet Baumel, totaling over $217,000. She'd taken out credit card advances and taken out a reverse mortgage to lend money to her. So based on all of that, Amy was devastated because her grandmother had very little money left. So she called 911 and reported the incident. And this is just, I just want to go over what Mariana told Amy and told the police about what Janet Baumel had said to her, the reasons she gave her for needing the money, and what she said about the money that she got. So again, she needed money to take care of her kids, for her son's drug treatment, for her own therapies and medical care, to invest in her new business. She promised that every check, except for the first one actually, was a loan, and that she would repay her with this money she was going to be getting from this car accident and from her job. So I think we don't have polling capabilities, but if you guys could answer in the comment section, that would be great. What do you think? Are Janet Baumel's actions criminal? Yes or no? And then why or why not? I would love, love, love to hear from you. I'll just give you a couple minutes to respond. And Kelly, if you're there, can you help me with any responses we might get?
Okay. So, yeah, the attendees are saying yes. And then I chimed in and myself and said, isn't lying to someone to get money criminal or could be criminal? So people are saying yes.
Okay. Oh yeah, and here's someone saying she had a verbal contract. Janelle, yes, because the intent was to influence her in a way to take that money. Kind of an undue influence idea there. Great. John seems to be taking advantage of someone in a vulnerable situation. Any others there, Kelly?
Not that I'm seeing on my.
I'm seeing one from Aaron, who's an attorney. I bet you're a civil attorney, Aaron, who
Yes.
said, okay, I've had cases similar to this and have been told no because the elder had capacity to create the POA. However, it could be a breach of fiduciary duty if self-dealing wasn't allowed. So one point about that's a great comment. One point about that is she did not use the power of attorney to commit the crime. So just from a criminal perspective, if Janet was writing the checks, we'd definitely be looking at whether we have a breach of fiduciary duty. And I want to talk more about that as we go. But she wasn't using the power of attorney to do that. So but I think it's still a huge factor, but it made it more complicated for us to charge it as a case of abuse of power of attorney. And then we have Mary saying, tough case to prove, certainly seems to have a criminal element. Her use of coercion and ultimately what she used the money for, questionable. Nice. Reba used deception, coercion, expected to pay back. Sarah, worth looking at from a criminal aspect, but you have to look at her capacity. So the charges probably would not hold. Okay. I think you guys are beautifully raising all of the issues I'm hoping to address today. So I'm going to keep going. So here's what happened in Washington. The patrol officer who responded to Amy's call had no training or experience in investigating elder financial crimes. She took a report and her agency, under-resourced as all of them are, particularly now, but this was a few years ago, didn't assign a detective to it. They didn't have the resources. They thought it was probably civil. And so they just said to this patrol officer, listen, you just keep investigating it in your spare time, which, as you guys know, is not an easy thing to do. She's working, responding to all sorts of crimes, including a lot of violent crimes, and to stop in her day and start trying to do search warrants and do all the things necessary to investigate these complicated cases was really a challenge. And the result was the case languished, as I'll talk about. But she did make a report to APS, which was great. The APS investigator went out, interviewed Mariana. As you guys can see, and this was a couple of years later when she was interviewed by the videographer. She's very articulate, and she was well kept. Her house was clean. There was nothing that indicated dementia to the APS investigator. So she concluded she was not a vulnerable adult, and she closed her case. She did not do any capacity screening or testing. And you guys, if you have other comments as we go, I can see them now. So feel free to go ahead and say something. And if I have time, I'll address them. We're doing fine on time. So I want to be to hear from you as much as possible. Okay, so we have the patrol officer working on the case for months. Again, little time, doesn't know what to do. And finally, thanks to Amy repeatedly calling the police agency, they agreed to assign a detective. This detective had also never investigated one of these cases, also had no training on them, but she called me, and together we worked a little bit on the case. I am frankly so overwhelmed that I don't track these cases. So if someone calls me from law enforcement, we'll work together and I'll give them advice. And then if I don't hear from them, I don't usually have the time to follow up. So I left it to her, and she did it. It took her a long time, but she did what she needed to do and did a very, very thorough and high quality investigation. And what I recommended that she do and what she did was obtain search warrants for the suspects and victims' bank records. And I always have them get those records dating back at least 6 months before we think the takings began, because we need to look at not only what happened during the time we think that the criminal activity may have occurred, but also to see what the victims' spending patterns were before that, and also to see what the suspects' financial situation was before they started stealing money from the victim. She also did warrants to get Bommel's medical records, to get her son's drug treatment billing records, to look for accident reports, and to get her employment records. And this is because if we have a case like this, where we have a victim who appears to be consensually giving money to a perpetrator based on what the perpetrator is telling them, and we suspect that what they're telling them are lies, we have to look into those lies and see if they are indeed lies, because we have to prove beyond a reasonable doubt, if we're going to be prosecuting this case, that these things indeed are not true. So that's like really the crux of proving a case like this. We also got Mariana's medical records and a capacity evaluation of Mariana. And so I'm wondering if you guys can tell me why we would want to get a capacity evaluation and medical records for Mariana. And we end up doing this really in every financial exploitation case that we get. It's now become routine if we don't have sufficient evidence of capacity. So it's, and I'll talk to you more about why, and the reason for it really depends on what type of exploitation case it is. So any responses there, Kelly?
Not yet, but I'll throw this out.
Okay.
Is it because when you give somebody money or loan somebody money, it has to be voluntary on your part, and if you don't have capacity, it's not voluntary.
Okay, absolutely. That's absolutely part of the reason. Looks like we've got some responses there. You see those?
I don't see them where I am.
Okay, I can.
Oh, wait a minute. Hold on a second.
Okay.
Oh, switch to the other button. Okay.
Okay.
So yeah, so to determine her ability to make the decision to give large amounts of money to a friend or perp.
Okay, so capacity, kind of like you were talking about.
Yeah.
Does she have the capacity to understand what she's doing and understand the impact on her finances?
Right.
Okay.
To determine her ability to make and understand her decisions, and medical issues may impact her ability to do so.
Great, Mary.
For evidence that she was taken advantage of.
Okay.
If she lacks capacity, then it would prove that she was unable to make the decision to give her money away. To determine if she has capacity to make her own decisions regarding finances.
Okay. Great answers. And go ahead.
Okay. And to test her judgment.
Great. Okay, that's a good answer. So one thing that I'll talk about a little bit in the future, but I want to sort of address right now is that when we have to figure out if she has capacity, I think for two reasons. One is to see what APS or whoever is involved with her, in this case it wasn't APS, but I'm guessing in Ohio it might be, to see what they might need to do and what her family might need to do to protect her in the future. But from a criminal perspective, we have to show not only, if we're going to proceed on a capacity theory, we have to show not only that she lacked capacity, but also that it was evident to the perpetrator that she lacked capacity, right? So that, when I looked at that and I talked to Mariana, I was like, that's going to be an uphill battle because she seems fine. So how do we prove beyond a reasonable doubt that Janet knew that she lacked capacity when she's so articulate? And it looks like there's a question from Bridget there, Kelly. Do you see that?
Yeah, it says, what if the doctor refuses to do a capacity screen? So what if you run into
well,
that?
Okay, we're going to talk more about capacity. I think it's a great question. We actually end up getting our capacity screening done by other people if the doctor doesn't do it, or if the doctor isn't really trained in doing capacity screening. So we end up using other experts to do an evaluation. So I'll talk more about that, but that's a great point, Bridget. Thank you. And I'd love to talk to Kelly hear from you about options in Ohio that might be available to people. So this is why capacity matters from my perspective, from a criminal perspective, which it's because consent is the most common defense that we see in these financial cases. I mean, almost always the perpetrator is going to claim, I was the only one who was there for her. She wanted me to have her money, or the money was a loan. I was going to pay him back, or his kids don't care about him. I'm the one who he cares about, and he wants me to have everything. And we can't tell if a victim consented unless we know whether they had capacity. And that's a lot of what you guys are saying here. We have to know if she understood what she was doing when she signed those checks. So it's very, very important. But it's also important to show why a victim might be, or an elder might be, easily deceived or manipulated. And depending on what the crime is we're looking at, we may also need to establish their vulnerability or their disability. And I think that's true for Ohio. So there's a bunch of different reasons why we have to figure out, how impaired someone might be cognitively, if they are. And we also don't want to be prosecuting someone if, in fact, they're just making decisions that we think are bad, but they're absolutely fine. And they're not being lied to, they're not being manipulated, and they have capacity, and then they have the right to do what they want. So it's really important to every aspect of our decision making. And finally, what I should have also included in here is it's important to figure out whether we need future services or protective action taken for the victim. So I'm going to stop now a little bit, or take a break from Mariana and capacity, and talk generally about it. And I just want to start out with a definition of dementia. It's, as you guys know, a general term for loss of memory, executive function, language, problem solving, and other thinking abilities, severe enough to interfere with daily life. Usually we see people's short-term memory going before their long-term memory. And what we also see very often, and this is the part that I think is often misunderstood by many people, including physicians, is that executive function may decline before memory does. And I'm just saying this from my own experience, but we've had so many cases where a victim like Mariana has seemed absolutely fine. And then we've gotten further testing and learned there are actually significant there was a significant impairment going on. So these are the different types of dementias that you guys can see. Alzheimer's is by far the most common that we see. Vascular dementia, second most common, that's from strokes. And frontotemporal dementia, which is frontal lobe dementia, really focused on executive function and judgment, is 10% of the cases in this study. Lewy body dementia is also significant, younger onset dementia, and then other diseases, including Huntington's and Parkinson's disease, is another portion of the pie. And we know that about half of people with dementia experience some form of abuse. And my guess, again, is the number is higher, but given the reporting issues that we face, this is all that the study found, but it's still a massive number of people really struggle who have dementia. And these next 3 slides are ones that were developed by Laura Mosqueda, who's a wonderful geriatrician at USC. And I've also modified them based on my own experience. But what we have seen with regard to early Alzheimer's, any early stage of dementia, where someone might be experiencing short-term memory loss or judgment impairment or word loss, is we see financial abuse as the most common form of abuse for that people at this stage of dementia. And then as the dementia progresses, and it becomes moderate or mid-stage Alzheimer's disease or dementia, where we start seeing people with behavior changes, loss of insight, more extreme judgment changes, physical abuse becomes more common. And then when we're talking about advanced Alzheimer's or dementia, where people are becoming bedbound, have swallowing impairments, or losing their ability to communicate, that's when we see most often neglect and sexual abuse. And obviously neglect we see it by far most common at this stage when someone is really utterly dependent on others, and we see so many people put in situations that simply aren't safe for them. And this is a slide I put together in preparation for this that I thought was pretty helpful, but there is some cognitive decline with normal aging, as we all know, and everyone, including me, is afraid of, what am I experiencing? Is this consistent with dementia, or is this just aging? And how do we know that? And this was just a chart that was put together by NIH that just talks about a few differences between normal aging and Alzheimer's disease. And I think it goes for any form of dementia. But obviously, we all make bad decisions once in a while. But with dementia, we're going to be making really poor judgments and decisions a lot of the time. It's just much more common that we're seeing routine issues with regard to good decision making. Real problems, regular problems, taking care of bills versus just missing a payment once in a while. Losing track of the date or time of year is more consistent with dementia versus forgetting what day it is and later remembering that. Trouble having a conversation. I've also heard that people with dementia may forget words for very basic things. Like, it's one thing to forget proper names, which sadly comes with aging, but forgetting the name of or the word for purse or computer or sort of basic things like that are not proper names can be a red flag. And then really losing things and being unable to find them, and sort of chronic misplacing of things or chronic disorientation, or anything like that, where you're really the person really is chronically having trouble functioning their activities of daily living, are when they should probably be evaluated. And then we also know that there's mild cognitive impairment, which is simply early stage of memory loss or other cognitive ability, but people who have that still maintain the ability to live independently and perform their ADLs. And we know that 12 to 18% of people 60 or over are living with MCI. And only 10 to 15% of people with MCI go on to develop dementia every year. So it's not true that everyone with mild memory loss goes on to develop dementia. Many people do, but not everyone does. So it's another diagnosis that I think we all need to be aware of in the field. So capacity is, when we talk about capacity, it's basically a clinical term, an assessment made by a psychologist or psychiatrist of someone's abilities. And you don't just have capacity or not have capacity, you have capacity to do a particular thing. So one capacity assessment that is often done is a financial capacity assessment. So what we ask the evaluator to do is assess the person for their ability to handle their finances and make a good financial decision. There's also medical capacity for the ability to refuse medical care or consent to a medical procedure. There's capacity to write a will. There's all sorts of different capacities, and a person may have the capacity to do one thing but not another. For instance, to handle finances, you need a very high level of capacity. So you may lack financial capacity in the early stages of dementia, but still have capacity to make medical decisions for yourself. So it's really important to be very specific when we're talking about capacity, to articulate what specific task are we talking about that the person may or may not have capacity to do. And what we see is that in early stages of dementia, financial capacity is very often the first thing that goes. And that as the dementia progresses, then we usually see loss of other capacities as well. If you guys have any questions about that, just chime in on the comments. So financial capacity, as I mentioned, is one of the first capacities that goes in the course of dementia. And we define it as being the ability to independently manage one's financial affairs in a manner consistent with their self-interest and their values. So that history of how they've spent money and how they've managed their finances is really important to figuring out whether someone still has capacity to make those decisions. And it involves not just counting money and writing in their check register, but also their judgment about what's a good decision for me financially and what's bad for me. And it encompasses the capacity to enter into a contract, to write a will, to give money. So all of those things are part of financial capacity. And I took this from this really great handbook for psychologists that's available online. And if you guys can't find it, send me an email and I'll send you the link to it. But it's an assessment of older adults with diminished capacity, and it's a handbook for psychologists, but it was written as a joint effort by the ABA and the American Psychological Association. And there's a lot of great information here, not only about financial capacity, but about medical capacity and other capacities. So as far as identifying and assessing cognitive impairment, we have sort of two general ways of doing that. We have capacity screening tests, and then we have capacity assessments. And Kelly, I'm going to ask you to jump in a little bit and talk about where people might get capacity assessments in Ohio. But as far as screening tests are concerned, I'm just going to give you a couple of slides on them. I'm sure you guys are very familiar with them. They're essentially short, standardized tests that just give basic information as to the older adult's functioning and whether they need a full-blown evaluation or assessment. A lot of primary care providers conduct them. A lot of APS investigators conduct them. And other non-mental health professionals can do it. They're only half-hour tests, and they just give us a snapshot of how that person is functioning at a particular time. The most common screening test historically that has been given is the MMSE, the Mini Mental Status Exam. And it's very useful for capturing memory loss, but it is not useful for capturing executive function impairment. So someone may do very well on this, even if they're in the early stages of dementia, because it may be that the dementia has not yet affected their memory. And again, this test is not good at picking up any kind of an impairment of their judgment. So that's a red flag about the MSE, and I've noticed it a lot because we've had a number of cases where people have scored very well in it, but we've been concerned about their capacity, have ended up having to follow up and do more testing. The other problem with the MMSE is that it's influenced by ethnicity and education, and it seems like it was written or created primarily with testing being done by Caucasian people, and it really doesn't do a good job of picking up impairment in people of other ethnicities and people who are less well educated. So it's got a real limited use from what I am learning from people and from my own experience. And these other tests end up being much better at picking up judgment impairment. And all of these, from what I understand, have some component that assesses executive function or judgment impairment. So the SLUMS is one, the MOCA is another one. The SPACED, which is another short test that was created by Jason Karlowicz at University of Pennsylvania, is another one. He also worked on the IDA, which is being used in California now and New York by APS. And the IDA is a really great tool, I think, because it's specific to the issue that the APS investigator is facing. So if a potential AV is refusing to take their medications, the IDA involves the APS investigator going to the person and talking to them specifically about why they're not taking their medications and what their reasons are, and really dives deep into whatever the issue is in front of the APS investigator. And it's a great way of really figuring out if this person's decisions that they're making make sense, and if they're good for them and encompass their values and are consistent with their past decision making. There's also a test called the frontal assessment battery that is specifically intended to assess for loss of executive function. So those are just some other options that can be really useful in just trying to pick up whether someone's got impairment and needs a further, deeper evaluation. So capacity evaluations are what we use whenever we have a case where we're not sure what's going on, or where we have a screening test that shows some impairment, or whether we just have concerns about whether or not this victim or alleged victim is understanding and truly consenting to the transactions that are at issue. And these evaluations involve lengthier interviewing and testing. They're usually not done by primary care providers unless they're a geriatrician. They're usually done by psychiatrists, psychologists, neuropsychologists, geriatricians, and sometimes MSWs with expertise in working with older patients. They're best done in the elder's home. We often ask for the evaluator to do them retrospectively. So we're asking them to tell us what the elder's capacity was at the time of the crime, which might have been a year or 2 or 3 years prior. And they're essential to us figuring out whether the elder had capacity at the time of the incident, and also for the other reasons we've been talking about. And Kelly, I don't know if you're able to talk about that, but if or anybody, if there's ideas for where in Ohio people can get these capacity assessments, it would be great to talk about that.
Well, I think a good place to start is with the adult's primary care physician to do, either an initial screening or, to refer them to somebody who can do the evaluation. And we are pretty fortunate in Northeast Ohio that we have some amazing hospital systems and medical systems, university hospitals, Metro Health, the Cleveland Clinic, the VA, that all have wonderful geriatricians and psychologists and psychiatrists to do the evaluations. Also, our adult protective services here in Cuyahoga County has kind of a unique, novel program where they have a nurse go out to the residence of the adult and does, takes blood pressure, does some, health screenings, and then gets a geriatrician on a video call to administer the cognitive test. At least, it's a screening tool, and if there are issues identified, the adult can be referred for more thorough screening, in an office setting. But so that's what we have here.
That is fantastic. That is so much more than we have. I think that's wonderful to have it be so accessible, because it really, it dictates how we all respond to these cases. And it's just essential to understanding if someone is making good decisions for themselves. And, what I've also noticed is in prosecuting these cases and we do a lot of trainings for prosecutors in other jurisdictions, is that as we all become more aware of elder abuse, we're also seeing some, I think, overzealous prosecutions where prosecutors, look at someone who's made what they think of as an inappropriate financial decision, and without getting a capacity evaluation, go ahead and prosecute the perpetrator. And we've really got to be careful about that, because, as I said earlier, we have the right to make decisions that other people might disagree with and that our kids may disagree with. And it's just so important to our understanding whether or not this person really is making the decision that is true to who they are. So there's a question, about the poll. Yeah, I think, so it looks like we've had some technological glitches that we can't do the poll. Does anyone, is that right about, Kelly, do you know?
I don't know.
Okay.
Our production people, would probably know that. But I do have a comment from OCAPS Ohio about primary care physicians are generally not trained in screening or conducting capacity evaluation. And that's true. It's just I guess it's a place to start if you don't have anywhere else to go, at least for a referral. But yeah, a lot of primary care physicians don't have that, training and ability.
And we're going to give you an example of that shortly. Yeah. So it's see-through. So the poll is available in the platform, even though the video is playing on YouTube. But Melanie's saying she can't see it. But the poll was, I mean, if you guys still want to do it, it was basically asking whether or not the case was criminal. And so we got a lot of great responses. But if you can access it, great. And we'll try to get the results towards the end of the presentation, if that's possible. Okay, I'm going to keep going here. So as I said, capacity evaluations can assess for financial capacity, susceptibility to undue influence in financial cases, usually capacity to refuse medical care. And that comes up a lot for me in the neglect cases that I handle, because also in those cases, the most common claim we hear from caregivers or from possible defendants is that the victim didn't want medical care. And in order to refuse medical care, you have to have capacity to make medical decisions. So again, we need capacity evaluators in those cases. And it comes up in cases of sexual abuse. Does this victim have the capacity to consent to a sexual act? So it's just crucial in almost every form of elder abuse that we respond to. Okay, I'm going to go back to Mariana. So here's what the capacity evaluation of Mariana revealed. And this is about a year, I think, prior to, probably 2 years prior to the video that you saw. And I think it's just so important to see this, because I certainly didn't detect any problems in listening to her on the video and watching her on the video. And if I'd walked into her home, I wouldn't have noticed anything. But she scored 19 out of 30 on the slums, which is really significant impairment. And the frontal assessment of battery, which is just looking at frontal lobe functioning, has a maximum score of 18, and she scored 11. So again, really significant executive function impairment that was not something that is easily noticed in talking to her. She had absolutely no insight into her impairment. She also was asked to do a clock drawing, which I'm sure you guys are familiar with, and which I've heard some geriatric psychiatrists say is the best indicator of executive function impairment. And I'll show you her clock drawing in a second. But she was diagnosed with dementia NOS. So she was asked in the clock drawing to draw a clock showing the time is 10 minutes after 11. And this is how she did. So the evaluator had concerns about the spacing of the numbers, but most significantly, obviously, the time was, it looks like maybe 5 minutes to 10 or maybe 10 minutes to 11, but not 10 minutes after 11. So that's a very telling sign that something's going on with Mariana. And this is what else happened. The investigation took about a year and a half, which is unfortunate, but unfortunately our reality. But what we learned in getting Mariana's medical records was that she'd been a longtime clinic a longtime patient at her clinic. There were notes from a bunch of different providers in the record. One of them indicated that she'd been scammed in the past, and a couple of different providers, I think nurse practitioners, and maybe a different physician who had dealt with her only once, had mentioned concerns about dementia. But she had scored either 29 or 30 on the MMSE. Her primary care provider had expressed absolutely no concerns about her cognitive capacity. So this goes to the comment we had earlier about primary care providers, that some of them are really well trained and others really don't have much specific training on dementia. And there was no additional testing conducted of her and no dementia diagnosis. So really very different conclusion in her medical records from what we got from the capacity evaluator. And I'll show you how that affected our case. Janet Baumel's medical records, which we also got because she was telling Mariana she needed money to pay for her treatment, showed that the only medical treatment she was getting was for an underactive thyroid, and she had health insurance. So that wasn't true. Then we got her son's drug treatment records. Actually, we just got the billing records because she said that she needed money to pay for his drug treatment. And it turns out he had gotten drug treatment and it was paid for by the state. So again, not true. And then we got her credit reports, which showed lots of debt and a lot of unpaid credit cards. So her motive was made clear by those credit reports. She didn't have any accidents that we were able to find in the state of Washington. And then we got her work records and found that she worked for a company called New Skin. I don't know if any of you guys are familiar with it, but it's basically where you, I think, buy a bunch of cosmetics and then resell them. But there was certainly no expectation she'd be getting any large payments from the company. So that was pretty clearly also a lie that she had told Mariana. And then we got Janet Baumel's bank records, as we do in all of these cases, because we've got to see not just what happened to the victim's money, but how the suspect spent that money. And what we saw was that when these checks from Mariana came in, Janet Baumel spent them on trips. She went to the East Coast once. She went to nice restaurants. She went to Coldwater Creek constantly. That was her favorite clothing store. Spiritual healing. She had a lot of spiritual healing. And we also saw that she had signed this power of attorney that Mariana had signed this power of attorney appointing Janet Baumel as her attorney in fact, which was evident in the bank records as well. So lots of interesting things here, but specifically what was most important was that we saw that the stories that Baumel was telling Mariana about why she needed the money were not borne out by how she actually spent Mariana's money. So my next question, I don't know if the poll will work or not, but if you can just comment if it doesn't, is could this case be charged criminally in Ohio? And if so, what charges? And OCAPS, I will tell you how we charge this.
Okay, so a comment was, or a question was, were you able to charge theft by deception in addition to her having lack of capacity for making financial decisions?
And I'm gonna keep you in suspense a little bit longer, and then I will tell you what we did shortly.
Fraud.
Which is that's your deception, right? It's the same thing as basically saying you get money from someone based on lies you tell them. Okay, Danny, good job.
Okay, exploitation.
Okay.
Abuse of an elderly person. Exploitation.
Okay, Karen. Fraud.
Abuse of the power of attorney.
Great. And then Loretta, not sure, maybe exploitation. Okay, it's not an easy case. Great answers, you guys. Okay. All right, thanks, Kelly. So here's what we did charge. We did charge theft by deception. So yes, you guys who talked about that are right. I'm going to talk a little bit about charging theories in a minute, but what made the most sense for us here was to charge theft by deception because we had such clear statements from Mariana about what the lies were that she'd been told by Janet. We actually even had on the checks that she wrote, a lot of times on the memo line, she would say for medical care or loan, which really helped us establish what each particular check was for. We also had a sentencing aggravator which allowed us to get a higher sentence above the 0 to 90 days, which is our standard sentence for any crime of theft over $5,000, which to me is shockingly low. But if the jury finds the victim was particularly vulnerable, then we can get up to 10 years in prison if they find that. So that was important for us to add on. So we also charge usually very conservatively in the beginning because we want to invite the defendant to plead guilty and take responsibility for what they did. And so I charged just one count, basically taking all of those thefts into account as an aggregated, sort of combining them all and just charging them over the several year time period that the incident had occurred. So now I'm going to dive into charging elder financial exploitation in Ohio. And forgive me if this gets a little bit dry, but I just think it's so important for everyone to know and for all of you guys to be on the same page about this. And Kelly, I ask you to jump in if I'm saying anything that's incorrect. Please let me know and just chime in because I'd love to hear from you and I don't want to misstate anything. So these next two slides are just lists of common elder financial exploitation crimes in Ohio. And again, this is just for your reference and you'll get this in the handout. The most common, the reason I have an asterisk is because it's absolutely the most common crime that we see, but securing writings by deception is another one that's very usable in Ohio. Identity theft or identity fraud is another crime that we see a lot in older victims. And there's some mention in the chat about undue influence, and we're going to talk about that too, because that's really important. So I'm going to talk now about your definition of theft in Ohio, and this is pretty consistent with Washington's and with most states. But essentially, theft prohibits someone from depriving someone else, the owner of property or services, from taking that property or services in any of these ways. And we call them the prongs of the theft statute. The prongs are without consent of the owner, beyond the scope of consent of the owner, by deception or fraud, by threat, or by intimidation. So those are the different ways in Ohio that you prove theft. And why do we care about these different prongs of theft? This is like, who cares if it's theft, it's theft, but it matters so much in helping us all determine whether or not, first of all, whether or not a crime is committed, but second, for those of us in criminal justice and for APS too, how we investigate it. If we're thinking this is a theft by a power of attorney and we're going to pursue this theft by power of attorney theory, then we've got to get the power of attorney document, right? We've got to look at whether Mariana or our victim had capacity to sign that power of attorney document. We've got to look at the gifting provision and that power of attorney to see whether it authorized the attorney, in fact, to take that money. So that dictates sort of what evidence we need to prove that prong of theft. If our theory is theft by deception, which again, it probably is going to be in Mariana's case for you guys, and as it was for me, we've got to look at what those lies were that the perpetrator told the victim and whether those lies indeed are lies or whether they're true. If it's theft by threat, then we have to look at how the victim was threatened, whether those threats were reasonable. Did anyone witness them? Like what exactly was said, and did it make sense that the victim felt so threatened that they had to turn over their assets to the perpetrator? And it's also important to show not only how we investigate or to establish how we investigate the case, but also to help establish how we charge the case criminally. So I, as a prosecutor, when I get a call from a detective about a case, I'm like, okay, so what prong of theft are we going to investigate? What do we think? What's our theory here about how this occurred? And then we talk about what evidence we need to prove that particular prong of theft. So I just can't emphasize enough how important it is to be thinking about that for all of us. And then it dictates how we prove the case at trial, what evidence we put on a trial, what witnesses we call, how we argue the case, and the jury instructions also depend on which prong of theft we're proceeding under. So it's just essential to our ability to properly file and handle a criminal case. And it's essential that you guys know that, so you know when to be calling law enforcement. And if you're not getting the response that you need, to talk to your local prosecutor or talk to a sergeant. So these are the sort of common ways elder financial exploitation is committed and the correlating prongs of theft. So we see a lot of takings, a lot of theft where the victim has dementia and lacks capacity to consent. So somebody with advanced or even moderate dementia may not have capacity to consent. And so our theory would be that the taking was without consent. And you guys have mentioned that in your comments. But one thing that's really important here is that we've also got to show in those cases that the perpetrator knew the victim lacked capacity to consent. So someone like Mariana, who seems pretty good, like for us to show beyond a reasonable doubt that Janet knew she lacked capacity, even though she did, is really hard. I would have a hard time being able to convince a jury that Janet knew that she wasn't able to make good financial decisions. I mean, maybe, but it's thin, and I think it would have really weakened our case if we'd gone forward on that prong of theft. Probably the most common prong of theft that we go forward on in elder cases is beyond the scope of consent, and that's where someone who is lawfully in control of the victim's assets, their attorney in fact or power of attorney, their guardian or conservator, their accountant, their attorney, anyone who's lawfully entrusted to handle the elder's funds, who spends those funds for themselves rather than for the victim, goes beyond the scope of consent. And in a power of attorney case, what we've got to do is look at the actual power of attorney document and see if there's a gifting provision and what that authorizes the suspect or the perpetrator to gift themselves in order to make a decision about whether they've gone beyond the scope of consent. So there's a question about exploitation, and I think that's correct, Mary. As I recall, as I understand it, and Kelly, jump in if I'm wrong, there isn't really a crime of financial exploitation in Ohio. So the crime that these cases would be charged under is theft, or one of the other ones I listed. And financial exploitation is sort of the umbrella term that we use and that APS uses to describe when an older adult is taken advantage of financially. Am I right, Kelly?
Yeah, that's exactly what I was going to say. I think exploitation is the broader, classification, and then individual crimes like theft by deception or theft by threat, securing writings by deception would fall under that exploitation umbrella.
Exactly.
Also, and maybe you haven't gotten there yet, in Ohio and probably most states, we have elder specs where the level of the crime can be increased if the victim is over 65 or disabled.
Right. And I will get to that, but please, if you want to stay on, Kelly, just while I go through this, I would love it.
Sure.
I don't claim to be an authority. So these are the other two prongs that we most commonly see being used in our cases is deception. And again, that's where we know the perpetrator lies to the victim, and the victim has to rely on those lies and giving the money over for it to be theft by deception. So cases like Mariana's, I think, are solid theft by deception cases where we can show what she was told, and we can show that what she was told was untrue. And she gave the money over in reliance on those lies. But it also uncovers stranger scams, sweetheart scams. I know you guys see a lot of those too, and we do too, where someone targets an older adult, befriends them, tells them, I'm in love with you, I want to marry you, and then immediately starts telling them a sob story about why they need money, and starts inducing them to hand over their money based on all these promises they're telling them, none of which end up being true. So deception is a really common crime against older adults, and I think there's a huge amount of misunderstanding by people who aren't who are in or out of the system about it being criminal. And I have just heard of a lot of cases in our jurisdiction where someone reports something like this and they're told, sorry, it's civil, this is not something we can do. And in fact, it's criminal as well as civil. And then there's theft by undue influence, which some of you mentioned. And this is also really important because it happens a lot in our cases. And this is where a perpetrator overcomes the victim's free will and gets their consent to their assets, to handing over their assets through isolation, creating dependence, undermining the victim's confidence, threatening to put them into a facility, really obtaining control over this victim's will. And those cases, even though that's not a crime in Ohio, are still chargeable in many cases. And we charge them as theft by deception or intimidation or threat. So just because a case is undue influence, do not take from that it's not criminal, because it may be. I'm getting some feedback, Kelly. Okay. Okay, so I'll just keep going, but Kelly will hopefully come back if she's needed and if she needs to correct me.
Okay.
So we describe undue influence as a pattern of manipulative behavior similar to grooming, involving usually victims who are isolated, vulnerable, may have some degree of dementia, and it's a process of gaining the victim's trust and dependence, isolating them, undermining their self-confidence, and manipulating them into consenting to turning over their assets. Again, it's not a crime in Ohio, but it is still a theory for how a perpetrator obtained a victim's consent. It's not a crime in our state either, and we use it a lot. We'll charge the case as theft by deception or some other form of theft, but we'll still say to a jury, clearly this victim was manipulated into consenting. So the consent that the defense is claiming was given was not true consent. So the fact that it's an undue influence case and the fact that we don't have crimes of undue influence in our jurisdictions does not mean these cases aren't prosecutable. We just have to charge them in a different way. And this is the civil definition in Ohio of undue influence. So we don't have a civil definition or a criminal definition, but you at least have this to sort of hang your hats on. But it's basically any improper or wrongful constraint, machination, or urgency of persuasion whereby the will of a person is overpowered and they're induced to do an act which they would not do if left to act freely. It's a really nice summary, I think, of what undue influence is. Anything else to add to that, Kelly?
No, I don't think so. But I wanted to jump in with a quick question, maybe
Sure.
to clarify. Somebody has asked, did Mariana's case get investigated solely by the prosecutor's office or by the police? And I'm going to just say, here in Ohio and in Cuyahoga County, generally the police do the investigations. And then once they, investigate, they'll consult with the prosecutor, to see, what charges should be brought, and then they'll bring it to the grand jury. I mean, we do have some investigators on staff, but the bulk of investigations actually are done by the police. I don't know if that's true in your jurisdiction as well.
Same with us. We work with 39 police agencies in our county, and they're the ones who do all the investigations. And then what we encourage them to do is call us early and often, because lots of times there's a lot of assumptions. This case isn't criminal. I'm not going to bother. So I just have them call me and talk about it, and we talk about whether it's viable, and if so, what investigation needs to be done. So the sooner they start working with the prosecutor, I think the less frustrated they become if the case ends up not being prosecutable, and the better they can sort of partner together and build a case together, which I think just is a win-win for everybody. But no, we don't have any investigators in our office, unfortunately. It's really a nice thing. But so our case, Mariana's case, was investigated solely by law enforcement. And as this detective who got assigned became more engaged and worked together with me more, she really ended up just doing a fantastic job. But it's hard when you're not working with the same people, and we have so many different investigators involved in our cases. And so, Kelly, this is what you were talking about. These are Ohio's enhanced penalties. And I talked about our vulnerable victim aggravator in Mariana's case. You guys also have kind of an aggravator where if the victim is 65 or over or disabled, the degree of theft is increased. And then you have this wonderful new legislation that was passed in 2019 that says that if the victim is elderly, there's no disability required, the offender shall pay, and it's financial exploitation, the offender shall pay full restitution and a fine of up to $50,000. And that fine goes to the Department of Job and Family Services specifically for responding to elder abuse cases. And it also applies to other financial crimes and not just theft. Any comment on that, Kelly?
Yeah, and just so you're aware, so we have degrees of felonies and misdemeanors in Ohio. A first-degree felony is the most serious. A fifth-degree felony is the least serious felony, and then it goes down to first-degree misdemeanor. And by increasing the degree of the crime, the felony or misdemeanor, you're increasing the potential sentence, prison sentence, jail sentence, fine. So that's why that's important.
And it's great. And it's important for us as prosecutors. It's important for families and for the community. And it's also really important for law enforcement. I mean, I've just seen what happens if the crimes aren't taken very seriously by the criminal justice system. And because they're so complicated to investigate, it really can be very discouraging for law enforcement because they put so much work into them. Okay, let's go back to Mariana's story. So after we filed charges, we had months of negotiations. I was worried about our case because I was worried about Mariana. We had some of these checks I told you that had specific amount, sayings in the memo line that they were for a loan or for medical care, but some of them said nothing. And Mariana did not remember by this point which checks correlated to which lies of Janet's. And Janet had told so many lies, that was also very difficult. So we actually did a deposition of Mariana. So we captured her testimony because I was worried about her dementia. I was worried she would lose her memory of what happened. So we did this deposition where we had a court reporter and we had defense counsel and Janet present. And I questioned her and defense questioned her. And we basically preserved her testimony so that if Mariana lost her memory in the future and wasn't able to remember things by the time of trial, we could use that instead. But we offered Janet a 12-month sentence, unagreed, so she could ask for anything. She could ask for no jail time because her standard presumed sentence was 0 to 90 days. And she rejected our offer and set the case for trial. And so I just want to give you a sense of what happened at the trial, just because I think it'll help complete the picture here. But eventually what we ended up doing was adding charges, because if she wanted to go to trial, we were going to be more aggressive. And so we filed 12 felony counts with aggravators, with the vulnerable victim aggravator. We had some already that were outside our statute of limitations, which was for theft by deception is 6 years. So that's how long this has been going on, given the delay in investigation. And then, we didn't hear about a lot of I think the first takings took place maybe 3 years prior to when the case was first reported. So between the investigation and prosecution, it was another 3 years before we got to trial. So it's just terribly long, and I don't feel good about that. But here's what we had to prove. With regard to each charge check, we had to show it was obtained by color or aid of deception. And we had to show that Janet Baumel intended to deprive Mariana of that money, although not permanently. It didn't matter if she was going to pay her back one day. It's still, she intended to take that money. And then we had 2 different degrees of theft, like Kelly was talking about. One was $5,000 and one was $750. So that was what we had to prove for each of those, depending on the degree of theft that we charged on that count. And so going back to what you guys were asking about the abuse of power of attorney, because Janet Baumel didn't use the power of attorney to perpetrate the thefts, we couldn't charge theft by going beyond the scope of consent. So we had to go by, in our state, that's called theft by embezzlement, where a power of attorney takes money beyond the scope of what they're allowed to take. But we did get in evidence of that power of attorney to show that Janet was aware of Mariana's financial situation and to show she had that heightened fiduciary duty to Mariana. There's a question here by Aaron: how do you have these crimes taken seriously when the victim lost money but still has remaining funds left? It's not even relevant. I mean, it's relevant to us as far as deciding how much of a sentence we want to recommend, how much money was taken, and sort of the impact on the victim. But as far as what happened at trial is concerned, we would keep out evidence of what the victim's remaining assets were. It's really not relevant to whether or not Janet committed theft. So if Mariana had $10 million when this started, which she didn't, and she was left with $5 million after Janet finished exploiting her, that fact of her remaining funds we would be making a motion to exclude that from being admitted at trial, because it really does not make any difference with regard to whether or not Janet committed those crimes. But if Mariana was completely devastated financially, which she was, that's something we're going to be certainly using at sentencing. So that's how it matters. So our strategy at trial was to show the big picture, show Janet's Baumel's lies, sort of explain through Mariana what the lies were that Janet told her, and then through the detective what evidence we found to show that those lies were actually lies. And then with regard to Mariana's cognitive impairment, we offered testimony from the capacity evaluator to explain why she believed Janet Baumel's lies. We ended up deciding we couldn't show that Janet knew she lacked capacity for the reasons I've talked about, but still that vulnerability was important to show why she would have believed Janet. We were really worried the jury might feel critical of her for continuing to give Janet money, even though it's clear she wasn't getting paid back. So that was really our general theory. We also had that vulnerable victim aggravator, and so we wanted to try to prove that, and so that was relevant for purposes of showing that aggravator to get above the 0 to 90-day standard range. Defense strategy, they claimed Mariana gave the money willingly. She consented, that Janet did indeed intend to one day pay it back, but for the fact that she got arrested, she would have paid the money back, was what they claimed. And that Janet didn't lie about everything. She'd said she needed some of the money for rent and clothes for her kids, which, because she was such an extravagant expender, she could arguably say that was true. But so there was some, her claim that she was telling the truth about some things. And these are our witnesses. We didn't end up needing the deposition. Mariana was able to testify, even though she didn't remember a lot of the details at that point. It was good enough, and we had the memo lines on the checks on some of those takings to, basically show why, with regard to some particular checks, we could show that it was a lie. But she remembered generally what the lies were that Janet had told her. So even though she couldn't say what she told her when, she could say all the different things, all the different reasons Janet gave her. And she could say that every loan that she made except for the first one, or every check that she wrote except for the first one, was in response to Janet saying it was a loan. So Amy testified, the capacity evaluator testified, the detective, the patrol officer, and we have a financial analyst in our office. Kelly, do you guys have one in your office? You're muted.
Yeah, sorry. We have some investigators who have backgrounds. They're usually retired police officers. We have a few who have backgrounds in investigating financial cases. Um, but there's so many cases that they're kind of stretched thin. I don't know if that's what you mean by financial analyst.
Yes, it is. And I don't know if Karen Webb is on here. I don't know if it's a Karen Webb I know, but I know a Karen Webb who's a terrific forensic accountant in the community who helps law enforcement and prosecutors with analyzing cases. And we have one in our office, and a lot of police agencies have one, and a lot of detectives have that skill. But it's really about taking these massive financial records that we end up getting in these cases and putting them into Excel spreadsheets. And then you can show from them, how the victim's money was spent by the defendant in categories, and really create this money trail from the victim to the defendant that's incredibly important to figuring out whether a crime occurred and for us to prove it at trial.
And we also have a state resource. We have the Attorney General's Bureau of Criminal Investigation that has forensic accountants and analysts there that we can refer cases. I don't believe they have original jurisdiction. I don't know if Sylvia's on here, but I think they'll come in by invitation to help out in a case.
And Sylvia Plaraith is a fantastic resource, and yeah, I can't emphasize enough how wonderful she is. She's yet another jewel in Ohio that you guys can turn to help with these cases. So defense called a bunch of witnesses, and really some of them were to create sympathy for Janet. The defense attorney called Janet's son and her daughter, and really what they were saying was that their mom was a good mom and just trying to create some sympathy for Janet Baumel. And then this is the thing that was most interesting to me was they called Mariana's treating physician. And this is now the third time this has happened to me in a case, because the treating physician, as has been remarked, missed Mariana's dementia, didn't do adequate screening, didn't do any assessments of her. And so he ends up becoming a defense witness at trial to testify that he had noticed no dementia in Mariana, that she seemed fine to him, and sort of to bolster their claim that Mariana was absolutely fine and had no capacity issues, which was still very relevant to our case, even though our theory wasn't that she lacked capacity. So on cross-examination, I had to ask him about the SLUMS and the MoCA and other capacity screening tests that are much better at picking up cognitive impairment, specifically executive function impairment. And it was, kind of embarrassing for him and uncomfortable, but it ended up being the result of a primary care provider who really had no training on dementia screening. So it was yet another reason why we really need to be working with healthcare providers on administering proper capacity screening tests. Different Karen Webb. Okay, there is another Karen Webb who is a wonderful financial analyst, but I'm glad you're here anyway, Karen. So the verdict on our case was that Janet was found guilty of 10 counts of theft 1 and 2. The vulnerable victim aggravator was dismissed because the detective had taken a video of Mariana early on in her investigation, and she'd lost the video. And so that became grounds for them to basically get us to dismiss the aggravator. The court dismissed the aggravator because we had lost that evidence. But regardless, the sentence was 43 to 57 months was the sentence range for Janet. The court gave her the low end of 43 months in prison. And she'll get a third of that, or she got a third of that off for good behavior. So it's not a terribly high sentence. I don't know what it would be like in Ohio, but for us in Washington, it was really a big victory, and really made a huge difference to Mariana and to Amy, who had been fighting by this time for years to get this case the proper justice that it deserved, and to get Mariana justice. So afterwards, we ended up lobbying the Washington State Legislature because we only had a theft crime, as I've talked to you about, and we created a crime called theft from a vulnerable adult. And it gave us a 6-year statute of limitations on every prong of theft. Before that, we only had a 6-year statute of limitations on our deception prong. And Amy and Mariana came to the hearings and actually testified in favor of this bill. And it was really empowering for them, and just a wonderful way to turn this negative experience into something positive. And the statute also, the new crime also created much harsher penalties. So instead of 0 to 90 days in jail, we're looking at now 12 plus to 14 months in prison for someone who commits theft from a vulnerable adult of over $5,000. And that has helped incentivize law enforcement and just helped encourage families in the community and mandatory reporters to report these crimes. And the New York Times ended up writing an article about Mariana and Amy, and that was really also very wonderful for them. So the lessons learned from my perspective from this case was how important it is to have trained and dedicated elder abuse detectives. It's so hard to investigate these cases without that training, and I just can't emphasize enough how important that specialization is to law enforcement. And same with prosecutors. We have so many prosecutors' offices in this country. I think the majority where we don't have people like Kelly who are dedicated to bringing these cases and know how to bring these cases. I have spent 2 hours on the phone with a detective in Washington State from a different county where they don't have a dedicated prosecutor. And he is asking me questions because he has no idea how to investigate the cases. And he's not even sure if he investigates the case, if their prosecutor will bring the case. And that's just a tragedy to me. So we just really need that training and specialization. We also need a multidisciplinary coordinated response in our communities, which we obviously didn't have enough of at that point when Mariana's case happened. And I know you guys have that in Ohio in spades, which is so important. And the importance of looking beyond apparent consent is another lesson learned. When we see older adults making unusual, substantial gifts of their assets, we have to look beyond what appears to be yes to deception, undue influence of the victim, and cognitive impairment of the victim. And understanding the elder's capacity is essential to our making proper and ethical charging decisions, to our making proper decisions about whether and what protective measures should be put in place. And in order to understand an elder's capacity, we need consistent screening with proper screening tests. We need capacity evaluations and assessments by qualified evaluators. And what I also learned from this case, as from many others that I've handled, is that elder financial exploitation is utterly devastating to these victims. As a result of this crime, Mariana had to declare bankruptcy. She had to move into an assisted living facility and sell her house. And she lost trust in other people. And I think most importantly or significantly to her was she lost trust in herself. And she really never recovered from this. As far as I know, she's still alive, but this was just a brutal, really awful experience for her. And I don't think she's ever really recovered from it. And we know from a study done by Mark Lax at Cornell Medical School that any form of elder abuse, even mild abuse, neglect, or exploitation, increases premature deaths in the elderly by 300%. So you're 3 times more likely to die a premature death if you've been financially exploited. And so that's all I have. And I think we've got a few comments, so I'll go to those. And if anyone else has any questions, don't hesitate to put them in. I think we've got about 7 minutes left. And this is my contact information. So if you guys ever have anything that comes up there and there's any way I can help, don't hesitate to reach out to me. And I really appreciate your wonderful attention and your comments. And Kelly, let's just take a few minutes and respond to those last comments. I'll go ahead and I see some of them. 12 months in prison for over $200,000, not bad. Loretta says it was actually, it's 43 months in prison, and then she got a third off, so she did about 24 plus months in prison. But yes, not a severe penalty. And yes, she was ordered to pay the money back. But that's based on her income. We don't have debtor's prison. So if she's making very little, once she gets out of prison, then she pays probably $20 a month in restitution. So, and that's very frustrating and a huge issue for us. What about early intervention screenings by the PCP? There were none in this case, except for the MMSE, which I've talked about, and very frustrating because I think they could have picked up on this vulnerability much sooner. Did none of the high amount checks draw attention at the bank level? Apparently not. The bank never reported this, even though they certainly could have. Another reason why it'd be wonderful if we had mandatory reporting for banks, which you guys do, as I understand it, for banks and investment brokers, and notary publics. So you guys really have a much better network for prevention than we do. Kelly, were you going to say something?
Nope.
Okay. Financial crimes are undercriminalized, undercharged, absolutely. yes, bank employees are mandatory reporters now in Ohio. So I think if this had happened in Ohio, you might have seen a very different outcome. Can I come in? Sylvia wanted to know if I could come and practice in Ohio. No, but I can come work with you guys at some point in the future. I'm not going to be here too much longer. I think I'm going to retire in 5 years or so. And my hope is to go into communities and work with people and help them improve their response to elder abuse. Okay, and there's one more question from Bridget. I'm an LSW in Ohio. How does an LSW who is involved with opening a criminal investigation of elder abuse find out if the case is still being investigated? Kelly, can you respond to that?
You could call the police officer, the detective who, is working on it, and they could keep you in the loop. I don't think there's any particular confidentiality, with the law enforcement end of it. You might not be able to get a whole lot of information from Adult Protective Services because of confidentiality, but I would, reach out to the police officer or detective assigned to the case to see, if you could get an update on it. We had a couple other questions that might be better, addressed maybe in the panel, or maybe answered in the workshops. One had to do with a developmentally disabled person who was being taken advantage of and what protections there might be for them short of a guardianship. There, could be a payee or maybe initiate a guardianship or get, somebody in there to handle the person's finances. And then we had a question also about that Netflix movie, I Care a Lot, about abuse of guardianships. So I think they're going to talk about the protections that we have in Ohio for wards under guardianship in that particular workshop, which will be available on demand.
Okay, great. I think there's a few more comments. We'll deal with those in the panel. Well, thank you, Kelly. Thank you. Thank you guys so much for your wonderful attention and your excellent comments. And I will be on the panel just in the background and can chime in if you need me at that point. Thank you so much.
All right. Thank you. All right. So thank you all for attending the keynote presentation. Paige Ulrey was wonderful. I learned a lot. I've been working in this area for a while, but I'm just always amazed at how much more there is to learn and find out. So a couple of things. I guess the technical issue with the video and YouTube has been resolved. So when you come back for the panel presentation, you're going to switch back to the swap card platform. It's my understanding. Let me check. Okay. I want to thank Liz King and Jennifer Clark. They're our tech people production company. They're the ones working behind the scenes. I could not do this. You could see from my involvement here, I have some challenges when it comes to tech. I'm getting better, but I'm learning, but they're working diligently behind the scenes to bring this to us. And before I let you go, I wanted to give you our CLE activity number for this session for attorneys who are involved. And, we can get you this information by email and stuff too, but if you want to write it down, 464-635. We've also been approved as a provider of CPEs for the accountancy board, and our sponsor number is CPE.00514. Our social work and counselor CEUs are pending, and we will get you that information as soon as we can. And it's just about time to go to break, I guess. Hold on, we've got some more comments. Okay. OCAPS Ohio says the Ohio Attorney General's office also has an elder justice unit that can help make connections, and they have a phone number here. And we have Adult Protective Services, here in Cuyahoga County and all the other counties that are a good resource. What we're hoping to do, with the network of agencies and people involved in this area is to have a way that you can get connected with somebody who can help you. So there's no wrong door, no wrong phone number to call. Whoever you call hopefully has the ability to refer you to somebody who can help if the person you've reached cannot help you. So cross referrals and and ways to network and get people the help they need and the answers they need. We also have a multidisciplinary team in Cuyahoga County, and I think most counties have that now, where we get together at least once a month and discuss cases and difficult cases, and multiple agencies and disciplines are involved, psychologists and attorneys and social workers, people from the housing area, law enforcement, first responders. So we have a lot going on in Northeast Ohio, and I think that's taking us just about to the end of our morning session. Hold on, I see something in the private chat. And time is up. So I'm going to let you go, and we will reconvene in 15 minutes for the multidisciplinary panel, and we can talk about this case and other issues that you have on your mind. Thanks.